Today we're going to talk to you about wills with special needs trust. What the heck does that mean? Well, it's a device that we use when we're trying to do asset protection planning. But we're working with a couple who says, I really don't want to transfer any of my assets currently into an asset protection trust. So they want to keep their assets, but they're concerned at death the husband's assets will pass to the wife. Now, she could be in a nursing home, that would be a real tragedy, or she could be elderly and may not need those assets immediately all at once. So what we can do in that situation is, at the death of the husband, instead of transferring all of the assets to the wife, we can pick some of those to say, I don't want those to go to my wife, but instead I want them to go in a manner that she will not have to spend them to pay for her nursing home care cost in the future. So how do you accomplish that? Well, a lot of people would have just said, why doesn't the husband give them to the kids? Well, in the state of Wisconsin, if he were to do that, that still would cause problems for the wife trying to become eligible for government benefits. So what do? We simply do? We make sure that the husband has in his will instructions to the probate court judge to place the money that he has running through probate court and put those into a trust that the judge sets up using the words that the husband put into his will. So nothing changes during the husband's lifetime. The husband and wife can both use the assets, but at the husband's death, we prevent the wife's net worth from being increased by having the husband's assets pile on top of the wife's assets. Thus, those assets are able to be used by the wife after the husband's death, just like they were before. They can be used by her, but she doesn't own them. And doing this does not make the wife ineligible for government benefits. Those assets can flow out to that trust, and from the trust, the wife can have access to that money and spend it as needed. Yet when she goes to the nursing home, there will not be any money in the trust that can be forced to be used for paying for her care in the nursing home. Thus, the government can come in and use its money to pay for the nursing home care cost, similar to the rules that we have out there when a wife has low assets, low income, and she'd be eligible for the government to help her pay for her care. Yes, she uses her income, but the government can come in and pay the difference. So here, this simply prevents the wife from being forced to spend the husband's assets before she can become eligible. Now, obviously, this is a strategy that we use when somebody is keeping significant assets, which I define to be more than $100,000 worth of assets. If they're keeping significant assets, we do not want those assets of the husband to be piled on top of the wife's assets when the husband dies. Obviously, if the wife goes into the nursing home while the husband is alive, it is absolutely critical that the assets the husband has retained be set up in this manner, whereby they get dumped into a trust for the benefit of the wife, so they do not count as her assets, so they do not take her off of benefits. So that's when it's absolutely required. However, you can do it early in anticipation that after the husband's death, the wife will someday need benefits. Now remember, what I just described was the husband dying first. We do exactly the same thing if the wife is alive and not in the nursing home, and the husband is alive and in the nursing home. We have the wife set up that plan. Also, if the wife is alive and healthy and the husband is alive and healthy, we set up the same plan for the wife in case she dies first. So in other words, it works either way. Works for having it in the husband's document and having it in the wife's documents. And again, remember, this only works if you're married, if you're a couple. A single person doesn't have this problem. They're not going to be dumping assets on top of the assets they have when they die. That's obvious. So again, remember the strategy, as the label on it is the Testamentary Special Needs Trust. Testamentary, we're setting it up under the last will and testament of the husband or the wife or both. Now, more information can be available by simply contacting our office at 414-634-6659. Now, the number you want to call is 262-634-6659. You can also get them information by going to our website, tpclaw.com. We have nice articles up there, and you can read those on this topic. If you'd like a free consultation, again, just call our office. That number is 262-634-6659. And we'll set you up with a free conference to talk about this subject, as well as any other subject that may be on your mind in the area of asset protection planning. We're trying to protect your assets so they do not need to be spent on nursing home care costs. Thank you for taking the time to watch this video.